Ogborn, Summerlin, and Ogborn first became involved in the case of Nunn versus in 2004. The case actually stretches back to 1999 when client Nicole Nunn was severely injured in a car accident. Nicole was thrown from the vehicle. The driver, Brian James, was deemed 100% at fault by his insurance provider. After the accident, Nicole moved to Florida to be with her family. She had hired Florida attorney Gil Powell to take her case.
The adjuster told Mr. Powell that since he was not licensed to practice in Colorado, he was engaged in the unauthorized practice of law, and she wouldn't talk to him any further. And as a result of that conversation, the opportunity to settle that case within policy limits was lost by
Nicole filed suit against Brian James in Colorado Federal District Court. She and Brian James entered into a stipulated judgment of $4 million. James then assigned his bad faith claims against to Nicole, and in return, Nicole agreed not to execute the judgment against Brian.
They put this agreement together and they put it in front of and they said, "We want you to sign off on this. We want you to agree to it." And so agreed, which then created the liability that gave rise to the bad faith suit.
They made a motion for summary judgment and based their defense on a Colorado Court of Appeals case, Cerna versus Kingston Enterprises.
What Cerna said was, if there is a covenant not to execute on a stipulated judgment, there can be no damages, and so there's no bad faith case.
Nicole's attorneys felt they had a strong case, but at the hearing, the judge ruled in his favor.
It was really kind of a heartbreaking day. Nicole was crushed, and we had come so far, and all she ever wanted was her day in court. And now the judge had slammed the doors to the courthouse in her face.
The plaintiff's attorneys appealed the decision, and Brad Levine wrote an amicus brief on behalf of the CTLA. But again, the court sided with the defendant.
We knew that the law couldn't stand that way. So we went ahead and we filed a petition for certiorari.
The insurance companies realized that this was probably not going to be a position that was going to be sustained in front of the Supreme Court.
By a 4-3 margin, the Colorado Supreme Court reversed the lower court's decisions.
What this case, what the Nunn case does, is it provides a mechanism by which the insured is going to be able to protect themselves from the bad faith conduct by the insurance company, and at the same time allow the victim to be able to have a mechanism for them to be able to get appropriate compensation. So the tool that this provides is a significant one. It means that, at least in the state of Colorado, that victims such as Nicole Nunn and folks who are in Mr. James's position are not going to have to just simply be left in the middle of the storm trying to wade their way through it.
At the end of the day, I think things turned out very well, both for Ms. Nunn and for everybody in Colorado. On behalf of Nicole Nunn, I would like to thank the Colorado Trial Lawyers Association for nominating Nunn v. Mid-Century for CTLA's Case of the Year.